Hello students, welcome to the next session of company law. In last lecture, we have talked about the alteration of share capital. We have discussed about the bonus issue and the right issue, uh, which are the powers or you can say the rights available to the equity shareholders. In today's lecture, we will talk about first reduction of the capital, and then we will proceed with the other part of it, that is the buyback of shares. Okay, so let's first discuss about reduction of share capital. The provisions are given under section 66 of Companies Act 2013. So let me just put on the blackboard. Reduction of share capital. The provisions are given under section 66. The provisions are given under section 66. Now when a company will go and reduce its share capital, there may be multiple reasons for a company when the company will go for the reduction of the share capital. So company may either go for the reduction of share capital for mainly three different reasons. So the first reason can be when the company is having accumulated business losses, assets of reduce value. Our company may go for the reduction of share capital. If a company is having the paid up capital in excess of the bonds, if you can say company is having paid up capital excess of wants. So these can be three major reasons where a company may go for the reduction of share capital. If a company is having accumulated business losses, assets of the reduced value, and if company is having excess paid up capital compared to its wants. Okay, so now we'll try to understand the procedure regarding the reduction of the share capital given under section 66 of the Companies Act. So what company will have to do? Procedure under section 66. So first, the reduction of the share capital should be done by passing the special resolution. You can say that special resolution in general meeting. For what? General meeting for, you can either say extinguish or reduce liability on any of its shares share capital not paid up cancel any paid up share capital which is lost on is unrepresented. And third category you can say pay off any paid up share capital which is in excess of wants of the company. Okay, so these can be the reasons for which company may go and pass the special resolution. First, extinguish or reduce liability on any of its share capital not paid up, which is not paid up. Okay, if company wants to extinguish or reduce that liability, company may go for the reduction of the share capital to that particular extent. Company may cancel any paid up share capital which is lost or unrepresented. Which is not represented, company feels that it is lost or unrepresented, let's cancel that particular share capital, company may reduce it. This point we have already discussed. Company may pay off any paid up share capital which company feels that it is in excess of the wants of the company. So for this, company will first have to pass a special resolution. Okay, then no such reduction shall be made if the company is in arrears in the repayment of any deposits accepted by it. Okay, so if the company has any kind of repayment of deposits and company is in the arrears of it, then company may not go for the reduction of the share capital. Okay, then company will have to issue a notice. Okay, first company will have to get the confirmation from the tribunal. So company will have to make an application to the tribunal for the reduction of the share capital. So tribunal has to give a kind of confirmation, then only company may proceed. So what is the procedure for that? First, application by a company to tribunal. Application by a company to tribunal. So tribunal here means the NCLT. Then what will happen? The next step would be, then tribunal will issue notice. Tribunal will issue notice. Okay, so tribunal will issue notice to various stakeholders. So the notice can be given to the central government, registrar and SEBI if it is okay, and the creditors. So to whom the notice can be issued? It can be issued to various stakeholders. So first it can be given to central government. The notice can be given to registrar. Notice can be given to SEBI if it is listed, and the notice can be given to creditors. So what kind of notice will be given? Because their representation is important, whether the tribunal should confirm the reduction of the share capital on the application made by the company. So tribunal first will confirm with all the stakeholders whether you have any kind of say for this reduction of the share capital, and the time limit will be given. The time limit will be given for all these stakeholders. Okay, after giving the notice, you can say tribunal shall take into consideration the representation within, I would say, within 3 months. Okay, within 3 months. तो 3 months के अंदर उनको representation देना पड़ेगा. If it will happen that okay, there is no kind of response or no representation has been received from these parties, then it shall be presumed that they have no objection to the reduction. If no representation has been received, then it shall be presumed that they have no objection to the reduction. Okay, so no objection will be considered in that particular case, and then finally the tribunal will pass order of tribunal for reduction of share capital if satisfied. So after confirming everything, the order can be passed, then it should be published, and that order should be published by the company as per the tribunal's directions. Then delivery of the certified copy of the order should be given to the registrar. Then the company shall deliver certified copy of the order of tribunal to registrar within 30 days. So within 30 days the order should be given, and then accordingly the registrar will issue the certificate, and okay, you can go for the registrar will issue the certificate to that effect. Will issue certificate to that effect. Okay, so this is the procedure, entire procedure for the reduction of share capital what we have seen. So step by step again we'll try to understand reduction procedure. The company will have to pass the special resolution in the general meeting. For what reasons? There can be three different reasons for which company may go. First, okay, or second or third, you can say extinguish or reduce the liability on any of its share capital not paid up. So the part of the share capital which has not been paid off, to extinguish or reduce that liability, company may go for the reduction of the share capital. Cancel any paid up share capital which is lost. So if company feels that okay, and with the of course evidences, company is though there is no one okay to represent it, or whether representation has been lost, which is lost or unrepresented, company may go for the reduction of that part of the share capital. Pay off any paid up share capital. If company the thinks that okay there is an excess of wants of the company may go for the reduction of the share capital. So say company while doing so, okay, if company is in the arrears, if there are already some deposits which have been accepted by the company and company has not paid those particular deposits along with the interest thereon, then company may not proceed with the share reduction of the share capital. First company will have to comply with those particular arrears, repayment of it, and then only company can proceed further. Now to whom to approach? Application should be made by the company to tribunal. Then tribunal will issue a kind of notice to may issue a kind of notice to four different stakeholders: central government registrar, if the company is the public limited listed company, SEBI, then creditors. Tribunal shall take into consideration whatever representation will be received by all the stakeholders will be taken into consideration within 3 months. If there is no representation okay has been received, then it shall be presumed that company will presume that the tribunal will presume that there is no objection for the reduction of the share capital by all these stakeholders, and then tribunal will proceed with the order for reduction of share capital if satisfied. Then company shall deliver certified copy of the order of tribunal to registrar within 30 days, and then in return registrar will issue a certificate to that effect. So this is the entire procedure, okay. By following with after following this particular procedure, company may proceed to reduce the share capital which has already been issued. So step by step you can just write down the pointers. So special resolution and three different reasons. Now we are going to proceed with the concept of buyback of securities. Important concept from exam point of view. Buyback of securities. Section 68. Buyback of security. So what is meant by buyback? So company may purchase its own securities. So that is the right given to the company that after issuance of the security, if company feels that let's purchase the securities, if company is having the lot of funds in the pre-reserves, company may proceed with the buyback, but there are some conditions to be complied with. So that is what we are exactly going to understand from these provisions. So let's first try to understand when a company may go for the buyback. So first, company buyback is the reacquisition by a company. So what is buyback? It is reacquisition by a company of its own securities. So it is nothing but a reacquisition by a company of its own securities, and it is a kind of way, it is a way of returning money to its investors. It is a kind of way to returning money to investors. So first we can say it is the reacquisition, means company will reacquire the issued securities by paying to the investors of its own securities. So company is nothing but company is reacquiring its own securities which were issued to the investors. It is a way of returning money to the investors, so for which company will have to make the payment to the investors. Normally it is seen that in case of the buyback there are multiple reasons for which company, the reasons are not stated anywhere in the section 68 for which reasons company should go for the buyback. There can be multiple reasons, like if there is a apprehension of the takeover, company promoter group wants to acquire the securities from the market so that no takeover should happen. That can be one of the main reason. When the company is having the funds, company may put the money, company may repurchase the securities by giving the premium to the investors, and then in the future company may reissue those securities at higher price. So there are multiple reasons. The reasons are not stated in the act, but this is the way by which a company can purchase its own securities. So there were multiple buybacks. Recently TCS had come up with the buyback, that is Tata Consultancy Services, where company had purchased its own, company had planned to purchase its own 5.60 crores of the equity shares of rupees 2850, and the last trading value, before the buyback was announced by the company, the last trading value was 2506 rupees. So company was ready to pay the premium of around 13% to the existing investors. So these are the mechanisms where the way the company's share price is going down, to stabilize the price company may go for buyback if it is having the the huge amount of the free reserves. Few years back even the Infosys had come up with the buyback of securities. So companies may come up from time to time, but now we need to understand the conditions which should be fulfilled for the provisions of the buyback, for the procedure of buyback. So which are those conditions as per section conditions, I would say, under section, as per section 68. Conditions as per section 68. Okay, so let's try to understand first sources of funds for buyback. Sources of funds from the buyback. So company can purchase its own shares, okay, or other securities. The purchase should be out of, okay, it should be out of free reserves. You can say there can be multiple sources, like it can be through free reserves, securities premium account, or it can be proceeds of the issue of any shares. Proceeds of issue of any shares. So if company has come up with the proceeds, like company had issued the other class of securities, company has accumulated the funds out of it, then company may use those particular funds for purchasing the securities. But there is a note given, you can say, while doing so, buyback cannot be made out, cannot be made out of the proceeds of an earlier issue of the same kind of shares. Earlier issue of the same kinds of shares. Okay, so if company has issued the proceeds, or company has issued the shares, and through those funds only company is going for the buyback, it will not be allowed. The buyback should be authorized by its articles. The buyback should be authorized by its, you can say, articles of association, AOA. But first I will write down all the pointers so that we can discuss it later on. A special resolution in general meeting company needs to pass. We need to understand the thresholds. Threshold, you can say, of buyback. Threshold. The buyback should be buyback should be 25% or less of the aggregate of paid up capital and free reserves. So company will have to ensure that it will be 25% or less of the aggregate paid up and free reserves. So this is the threshold. Okay, I will just highlight this. If buyback is %10 or less, if buyback is 10% or less, of paid up capital and free reserves, okay, then it can be authorized by board resolution. The ratio of aggregate debts, secured or unsecured, owed by company after buyback should not be more than twice. Of paid up plus free reserves. So they should not be the ratio of 1:2 after buyback. There are so many conditions given under the buyback. Shares for buyback should be fully paid up. So company can only go for the buyback for the fully paid up securities. Company cannot go for the partly paid up shares, shares of listed companies should be made in accordance with SEBI regulations. Okay, so buyback for the listed companies basically should be as per the SEBI regulations. No offer of buyback shall be made within 1 year from the close of preceding offer of buyback. Preceding offer of buyback. Then time limit buyback should be completed within 12 months. From whom buyback can be made. So if this question is there, then it can be from existing shareholders on proportionate basis, open market, or it can be from ESOP or sweat equity. Declaration of solvency has to be there before buyback. Then extinguishment of securities, it should be done within 7 days. Within 7 days. Cooling period, a company shall not make further issue of same securities within 6 months. Register of buyback. Filing of buyback return. Filing of buyback return within 30 days. To whom? Registrar and SEBI. Okay. So this is a lengthy procedure of the buyback which I have written down on the screen. As you can see, the buyback of securities, the provisions are given under section 68. So as I told you, it is a kind of requisition by a company of its own securities, and it is a way of returning money to the shareholders. So what are the conditions? First of all, there should be sources of the buyback, okay, from where the company can company can purchase the securities of its own securities. Either it can be done from the free reserves, securities premium account, or proceeds of issue of any shares, proceeds of issue of any other class of shares. So if a company has received the funds, company may utilize those funds for purchasing its own securities under the provisions of buyback. Buyback cannot be made out of the proceeds of an earlier issue of the same kind of securities. Okay, so if there is same kind of securities and company is using those proceeds only for purchasing securities, it is not allowed. So different kind of securities can be used but not the same kind of security. Then it should be authorized by its articles. The buyback a company can go for buyback, somewhere it has to be written and where it should be authorized under articles of association. So company should be empowered to proceed with the buyback under articles of association. Special resolution will be required to be passed. Okay, so when a company is going to pass the special resolution, a kind of explanatory statement should be prepared. The explanatory statement should state the material facts, the need for the buyback, the all possible information should be given to the shareholders of the company so that they can come to the informed decision. So what is the need of the buyback, which types of securities company is intending to go for the buyback. So all such information should be given under the explanatory statement. There is the time threshold given. What is the threshold? Okay, the buyback should be 25% of the less of the aggregate of paid up capital and free reserves in one financial year. So company will have to ensure that during the financial year 25% or the less, okay, only company can go for the buyback. If my paid up capital is 1 crore rupees, then I can only go for the buyback of 25 lakhs of paid up capital and free reserves. Okay, whatever the amount. So if my paid up capital is, let's say, 75 lakhs rupees and free reserves is 25 lakhs, so my total is coming around to 1 crore rupees, then I can go for the buyback, okay, for on behalf of the company for 25% of it, that is 25 lakh rupees. If buyback is 10% or less, so there is one kind of, you can say, exemption is given. If the buyback is for the lesser amount, let's say 10 lakh rupees in my case, then I do not have to go to the shareholders for passing the special resolution. So company has been exempted from passing the special resolution if buyback is only for 10% or less. So board of directors of the company can take that decision. They can pass the resolution and they can proceed with the buyback. So it can just be authorized by whom? Board of directors, by passing the board resolution. Company will have to ensure that post buyback the aggregate ratio, the ratio of aggregate debts, okay, owed by the company after buyback should not be more than the twice of paid up plus free reserves. So they should not be, okay, the ratio should not exceed 1:2 basically post buyback. So company will have to think before going for the buyback from these particular aspects. Shares for buyback should be fully paid up. Shares for buyback should be fully paid up. Okay, company shares, okay, whatever the company is offering or the price company is offering, the shares should be fully paid up. Buyback of shares of the listed company should be made in accordance with SEBI regulations. So whatever SEBI regulations for the time being are there for the listed company should be complied with separately, okay, in addition to the Companies Act 2013 provisions. No offer of buyback shall be made within 1 year from the close of preceding offer of buyback. So if a company has gone for the buyback during the preceding 1 year, then company first have to complete the 1 year. Company will have to complete the 1 year, then only company can again go for the buyback. So if company is not completing 1 year and then again company wants to go for the buyback, it is not possible. So there has to be a gap of 1 year, okay, before going for the next buyback. So you can say within a 1 year no offer of buyback can be made. Okay, there is a time limit given. Buyback should be completed within 12 months. So company, if it is going for the buyback, okay, if company wants to do the buyback after passing the board resolution or the special resolution, as the case may be, okay, company will have to complete the buyback from the date of that resolution. The 12 months timeline is given for the same. What a company can do, from whom the buyback can be made, company can either go to the existing shareholder on proportionate basis. Okay, proportionately company can allow them to sell the securities. Company may openly keep the buyback offer to the shareholders. This is very popular. And from ESOP or equity shareholders, sweet equity shareholders, company will have to give a kind of declaration of the solvency, that okay, company will not become solvent for that matter, because if the company is solvent, only insolvent, company will not become insolvent. If the company is solvent, then only company should be allowed to go for the buyback. After the buyback, the securities will come to the company. So there is a procedure for the extinguishment of the security. Company will have to destroy those securities within a period of 7 days. The timeline is given. After the last buyback will happen, company, after completion of the last buyback, company will have to destroy the securities, okay, under buyback within a period of 7 days. There is again a cooling period. What is a cooling period? See, company has completed the buyback and again company wants to issue the same kind of securities to the shareholder. Can a company do so? Answer is no. Company will have to first go through the cooling period of 6 months. So there is a timeline given. First you complete the 6 months. You want to reissue the securities of the same buyback. You can do it, but only if you can complete the 6 months period. Company will have to maintain the register of buyback, whatever securities company has received under the buyback, then whatever securities which have been extinguished, everything, all the records should be maintained properly. Filing of buyback return within 30 days. Company will have to ensure that company will file the return of the buyback within 30 days. There can be penalty part also. There can be penalty if company makes the contravention. There can be again two types of penalty, as we have seen earlier also, for company and every officer. So what is the penalty? For a company, it will be rupees 1 lakh to rupees 3 lakhs. Rupees 1 lakh to rupees 3 lakhs. If a officer is making a default, imprisonment can be there up to 3 years. Up to 3 years, or imprisonment up to 3 years, or fine rupees 1 lakh to rupees 3 lakhs. Okay, so this is the kind of penalty if the default is made, okay, with the provisions of this buyback of securities. I hope you have understood this provision. So if you want to make a note of it, please do it. So conditions are important. It should be done from which sources? So sources of buyback, sources of funds. I should highlight this part. Sources of funds. After that, you talk about these important pointers. Special resolution, threshold, then how much buyback can be possible during the financial year, if as per the board resolution how much it's possible, what should be the ratio, it should be 1:2 maximum, not beyond that. Shares for buyback should be fully paid up. From whom buyback can be made? Existing shareholder on proportionate basis, open market, from ESOP, sweat equity shareholders. Company will have to file the declaration of solvency. Extinguishment is important provision, the compliance on the part of the company, and there should be a kind of cooling period of 6 months. I should highlight that part. Cooling period of 6 months. The last slide, register of the buyback return within 30 days to the registrar and SEBI. Penalty, company, if it is a company, rupees 1 lakh to, this is a fine, this is fine of rupees 1 lakh to 3 lakhs, up to 3 lakhs. Every officer, imprisonment up to 3 years, or fine of rupees 1 lakh to 3 lakhs. So that's it from my end today. So we have completed two important provisions today. So reduction of share capital under section 66, how it can be made, the procedure relating to it, and the buyback of securities. So student, with this we have completed the first part of the chapter 4 of the Companies Act relating to the share capital. Okay, mainly we have not yet started with the debenture. Debenture is a smaller part of it, and then after completion of the debenture we are going to complete with the chapter 4 of the Companies Act 2013. So thank you so much for watching this video. Do watch this video, do the revision properly. We will come up with the next topic very soon. Till then, goodbye.